In this episode, we will be discussing Arizona tenant noncompliance. The Arizona Residential Landlord and Tenant Act gives landlords the right to take the following action against tenants that violate the terms of a lease agreement, provide false information, or commit criminal acts on the premises. Material noncompliance or falsification. If there is a material noncompliance by the tenant with the rental agreement, including material falsification of the information provided on the rental application, the landlord may deliver a written notice to the tenant specifying the acts and omissions constituting the breach, and that the rental agreement will terminate on a date not less than 10 days after receipt of the notice if the breach is not remedied in 10 days. For the purposes of this section, material falsification includes the following untrue or misleading information about the number of occupants in the dwelling unit, pets, income of the prospective tenant, social security number, and current employment listed on the application or lease, as well as the tenant's criminal records, prior eviction record, and current criminal activity. Material falsification of information in this section is not curable under this section. Noncompliance affecting health and safety. If there is a noncompliance by the tenant with the laws in our video titled Arizona Tenant to Maintain Fit Premises, materially affecting health and safety, the landlord may deliver a written notice to the tenant specifying the acts and omissions constituting the breach, and that the rental agreement will terminate on a date not less than 5 days after receipt of the notice if the breach is not remedied in 5 days. However, if the breach is remediable by repair or the payment of damages or otherwise, and the tenant adequately remedies the breach before the date specified in the notice, the rental agreement will not terminate. If there is an additional act of these types of noncompliance of the same or a similar nature during the term of the lease after the previous remedy of noncompliance, the landlord may institute a special detainer action 10 days after delivery of a written notice advising the tenant that a second noncompliance of the same or a similar nature has occurred. Material and irreparable violations. If there is a breach that is both material and irreparable, and that occurs on the premises, the landlord may deliver a written notice for immediate termination of the rental agreement and shall proceed filing a special detainer action with the court. Examples of such material and irreparable breach include, but are not limited to, the following: illegal discharge of a weapon, homicide, prostitution, criminal street gang activity, unlawful controlled substances, threatening or intimidating the landlord, the landlord's agent, or another tenant, assault, being a nuisance, jeopardizing the health, safety, and welfare of the landlord, the landlord's agent, or another tenant, acts of imminent or actual serious property damage. It is important to note the tenant shall be held responsible for the actions of the tenant's guests that violate the lease agreement or rules or regulations of the landlord if the tenant could reasonably be expected to be aware that such actions might occur and did not attempt to prevent those actions to the best of the tenant's ability. Unpaid rent. If rent is unpaid when due, and the tenant fails to pay rent within 5 days after written notice by the landlord of non-payment, and the landlord's intention to terminate the rental agreement if the rent is not paid within that period of time, the landlord may terminate the rental agreement by filing a special detainer action. But before the filing, the rental agreement shall be reinstated if the tenant tenders all past due and unpaid periodic rent and a reasonable late fee set forth in a written rental agreement. After the filing, the rental agreement is reinstated only if the tenant pays all past due rent, reasonable late fees set forth in a written rental agreement, attorney fees, and court costs. After a judgment is awarded the landlord, it is solely in his discretion whether to reinstate. Damages and attorney fees. The landlord may recover all reasonable damages, court costs, reasonable attorney fees, and all quantifiable damage caused by the tenant to the premises resulting from non-compliance with the rental agreement or the laws in our video titled Arizona Tenant to Maintain Fit Premises or Occupancy of the Dwelling Unit. For additional laws and articles, visit AmericanLandlord.com.